Well, thank you all for being here. Thank you, Lyle and Tom and the Federalist Society for inviting me to come to Lincoln. It's great to be here. As I got off the plane, or someone on the plane, or maybe it was the rental car people, were telling me that Nebraska's motto was the dry-friendly state. And I thought, wow, Nebraska must be the last dry state in the country. Until someone corrected me as to the motto being dry-friendly. I want to thank you for coming today to hear about the little-known case of Roe versus Wade. And I realize that that seems ludicrous, but I would suggest that the Justice's papers, which have been released to the public over the last 10 to 15 years, tell a completely different history than you've heard before. And it's an important history. So I want to recommend the book itself, Abuse of Discretion, which relies heavily on the Justice's papers. But I also wanted to just note, in addition to the article that Lyle mentioned, my Washington and Lee Law Review article in 71 Washington and Lee 827, and a second article that kind of updates the manuscript in Abuse of Discretion is in the Villanova Law Review entitled A Roadmap Through the Supreme Court's Back Alley, and that's published at 57 Villanova 45. And both of these update with data and case law the chapters in Abuse of Discretion. But I started on this journey in writing this book back in 2008. And at the time, I was struck by a number of questions. What's available of the record? Why did the justices issue such a broad ruling? Why has Roe versus Wade been so controversial, and the controversy doesn't end 41 years later? What did they have before then? What kind of record did they have? Were there still audios of oral arguments? Could I find a transcript of the oral arguments? And when I started looking, I discovered that you can find the transcript of the Roe oral argument and the audio, and there's a great website, if you have never visited it before, called oyez.org. As you know, oyez is part of the Supreme Court clerk's opening announcement of public sessions of the Supreme Court. But if you go to oyez.org, and you can find the original Roe versus Wade case and the companion case of Doe versus Bolton, you can read the transcripts, and you can hear the original audios of the original arguments, and maybe to whet your appetite, you should go and listen to the first opening argument in Roe versus Wade in 1971. The Texas Assistant Attorney General apparently had never argued the case before the Supreme Court before, and he starts out with this abysmal joke to the justices, at which they glare down at him, and then the oral argument kind of goes down from there. So I won't tell you what that is, but you should go hear the original argument in Roe versus Wade. So the full 4 hours of 2 sessions of oral arguments are at oyez.org, and it's if you read the transcript and listen to the audio at the same time, it becomes very clear as to what they were talking about. So I was just struck by these questions, and I found the audio and the transcript, but Doe versus Bolton, the transcript and the audio weren't available then, and only recently became available at oyez.org. And then I was and I would also mention that Doe versus Bolton is a historic case, not only for its outcome, but I talked with Dorothy Beasley, who was the Assistant Attorney General for Georgia, who argued both the first round and the second round of arguments in Doe versus Bolton. She was the Assistant Attorney General. And she told me that the clerk had told her that Doe versus Bolton was the first time in Supreme Court history that 2 women sparred off against each other on both sides of the questions in Doe versus Bolton. But after finding the transcripts and the audio, I then wondered, what about the justices' papers? Are they available? Can I get access to them? Where are they? And many of the justices' papers are at the Library of Congress, and you can easily get access to them. But they're also now been released at Yale University, Washington and Lee University, Stanford University. And Today, you can look at the papers of 8 of the 9 justices, the papers of 8 of the 9 justices who voted in Roe v. Wade, all but Chief Justice Burger's, which are embargoed or sealed until 2025. And you might think there's some federal statute that governs the justices' papers and maybe regulates what's in them and when they're released, but there isn't anything like this. I was shocked. Each justice has an individual right to determine what goes into the papers and when they're released. So, for example, Justice Souter has put his off till 2050, and Justice Marshall authorized his to be released on the day after he died. And that caused certain tension within the court because his papers were released when justices he was serving with were still on the bench. But the papers are fascinating. Justice Blackmun was kind of a pat rack, and so there's an enormous amount of clippings and papers and memos and handwritten notes between the justices in his papers, which you can look at. But Justice Stewart kind of vacuum cleaned his papers, and about the only thing in his papers is officially printed copies of drafts of Supreme Court opinions out of the Supreme Court print shop, and that's about it. So his are relatively unexceptional. But the papers are fascinating, and so I think that Abuse of Discretion is the most important book about Roe since Roe, simply because these papers have been released to the public over the last 10 or 15 years. This book couldn't have been written 15 years ago, because Blackmun's were released in 2014, and a number of the most important papers were released since then as well. The book couldn't have been written before 2004. So if you want to understand Roe versus Wade, I think the papers of the justices are essential. And they're essential because they have filled an historical gap. Because one of the things I found out is that there was no record in Roe versus Wade or Doe versus Bolton, which I'll get into. And so Abuse of Discretion tells the story of the deliberations from 71 through 72 up to the release of the decisions, the behind-the-scenes deliberations that went into the decisions in Roe versus Wade and Doe versus Bolton. And here's the spoiler alert. The movie out next year, Abuse of Discretion, will star Johnny Depp as Justice Blackmun, and Adam Sandler's going to play all the other justices. So watch for that coming. Before I go any further, though, I think I need to explain the impact of Roe versus Wade and Doe versus Bolton. What the public knows, what the media talks about, is the case of Roe versus Wade. But of course, it's really two cases. It's Roe versus Wade and it's Doe versus Bolton. And the court said that the two have to be read together, or should be read together. The court in Roe said they are to be read together. And in Roe, the court suggested that the states could prohibit abortion after fetal viability, quote, except where it is necessary in appropriate medical judgment for the preservation of the life or health of the mother, unquote. But then in Doe, the companion case issued the same day, the court added a significant health exception that is often overlooked. The justices defined health as, quote, all factors, physical, emotional, psychological, familial, and the woman's age, relevant to the well-being of the patient, unquote. So health in abortion law, in constitutional abortion law, means emotional well-being without limits. And the health exception swallowed the supposed ability of the states to prohibit abortion after fetal viability. So Roe and Doe were sweeping decisions. And they basically left the U.S. as one of only 4 nations of 195 across the globe that allow abortion for any reason after fetal viability. One of 4 nations of 195. And as I got into the papers, I was frankly shocked by some of the things I found. And the first was that I was surprised to find that Roe and Doe were taken and then heard under the misapprehension that they only dealt with an application of Younger versus Harris. You may remember Younger versus Harris as a state federal jurisdiction case. And Younger was a divisive case, argued 3 times before the Supreme Court and decided in, I think it was February of '71, just 60 days before they voted to take Roe and Doe. Younger versus Harris dealt with the question of whether a state court criminal defendant could take their case out of state court into federal court. And Roe versus Wade and Doe versus Bolton kind of dealt with a similar factual situation. And if you read Woodward's The Brethren, Woodward explains this state-federal jurisdictional tension from Justice Douglas's viewpoint, and makes clear that, in fact, they did take the cases to decide the application of Younger versus Harris. Could a state court defendant, a doctor prosecuted for abortion in state court, take his case in the federal court? So the court that took Roe and Doe consisted of, in the back, it's Justice Marshall, Stewart, White, and Blackmun, and in the front from the left, it's Justice Harlan, Berger, Douglas, and Brennan. And the court took Roe and Doe 60 days after deciding Younger in order to decide the application of Younger. And this is borne out by bench memos to the justices, by the original jurisdictional statement, and by a number of communications back and forth. But then the critical moment came in September of '71. They took the cases in April of '71. In September of '71, Black and Harlan retired within the space of a week due to ill health. Black died at the end of the week. There was a big national funeral, and Harlan died at the end of 1971. So this basically created a crisis in the court for 15 weeks during the vacancies. It reduced the number of justices to 7. It completely flipped the balance of the court, and these 7 are the justices who heard Roe and Doe for the first time, the first round of arguments in December of 1971. It's by reducing the number of justices to 7, it flipped the balance of the court, and it empowered a temporary majority of justices, most notably Douglas and Brennan, and to a lesser extent, Stewart and Marshall, who decided to use Roe and Doe, which were taken to decide the jurisdictional question, and they saw the opportunity to declare a right to abortion, sweep away the abortion laws, and get the cases decided as quickly as possible. Now, they weren't decided on the timeline that the 4 wanted them decided, because they rescheduled the cases for oral argument, which I'll get into. But these are the 7 that first heard the arguments in Roe and Doe, and when they get to the conference in December of '71, they basically vote to declare a right to abortion and sweep away the abortion laws. And Berger decides to assign the opinion to Blackmun, which itself created a crisis in the court, because the 4 thought that the voting at the conference was 4-3, that Blackmun and Berger were in the minority, and therefore Douglas should have assigned the opinion to himself. In fact, he started writing a draft of an opinion. But then Berger said, well, the voting was obscure, and so I'm going to assign it to Blackmun. And Blackmun kept the assignment of the opinion. Blackmun, in his kind of oral history, subsequently said he really didn't know why the opinion was assigned to him, and you can speculate it was because of Blackmun's expertise as resident counsel at the Mayo Clinic in the 1950s, perhaps. Maybe it's because Berger assigned it to Blackmun because Berger thought he could control the opinion more. You know, you can speculate, but Blackmun, in his oral history, says he wasn't exactly sure why the opinion was assigned to him. But nevertheless, he starts to write the opinion in December of '71, and doesn't distribute drafts to the other justices until May of '72. But the problem is that by the 4 taking these cases to decide Younger versus Harris, they basically created what I consider a major procedural mistake and a major mistake of judicial process, which was that these cases didn't have any trial record. There was no record in these cases. There was no trial, no evidence, no expert witnesses. And if you step back and think about Justice Harlan and Black being among those who took the cases in April of '71, that kind of makes sense, because if you're going to decide state and federal jurisdictional issue and the application of Younger versus Harris, you don't need a trial or any evidence on the abortion issue substantively. It's just the procedural issue that they were going to address. But when the four decided to take these cases, they took 2 cases out of 20 or more that were in the courts, and these cases had no trial, no record. In fact, if you go to the oral arguments, the Assistant Attorney General for Texas said to the justices, quote, "The record that came up to this court contains the amended petition of Jane Roe, an unsigned alias affidavit, and that's all." And Dorothy Beasley, the Assistant Attorney General for Georgia, told the justices in Doe versus Bolton, quote, "And that again is one of the great problems with this case. We know of no facts. There are no facts in this case, no established facts," unquote. So, because there was no trial record, and at the time there was a federal statute that said that cases from 3-judge federal district courts could go straight up to the Supreme Court. So there was no intermediate appellate review whatsoever. And so with that record, the case had gone from the federal district court up to the U.S. Supreme Court, and that was the record they got. So in this great factual vacuum, the justices, unfortunately, were tempted to rely on their hunches and prejudices and experiences in deciding these issues because they had no facts and no record. The second problem, I talked about the kind of shift of balance of power, but the second problem is that the justices latched onto one major medical sociological assumption that drove the entire outcome, and that was the assumption that abortion is safer than childbirth. Abortion is safer than childbirth. How did they get this notion? Well, there was no record, so they got it through friend of the court briefs filed in the Supreme Court by interest groups. And the medical assumption, you can read it, I think it's footnoted in page 149 of the Roe opinion, and then it's referred to, I think, on page 163, and there's a footnote with 7 medical articles that the justice referred to. But these medical articles, for the most part, are based on data from Soviet bloc countries in the 1950s. And if you look into the articles, as I do in Abuse of Discretion, none of the articles have any reliable data whatsoever comparing the safety of abortion, which is based on mortality rates, with the safety of childbirth, which is based on mortality rates. So it's comparing the abortion mortality rate and the childbirth mortality rate in Soviet bloc countries in the 1950s. But these articles don't support that comparison. They don't support the notion of abortion safer than childbirth. But this medical assumption is the key factual assumption in the Roe and Doe decisions. And when you read them together, looking at this medical assumption, you can see that first of all, they influence the justices to prohibit health and safety regulations in the first trimester when 90% are done, because it's safer than childbirth. It encouraged the justices to create great deference to providers, as it's safer than childbirth. It also encouraged the justices to expand the abortion right that they were creating up to viability and beyond, because it's safer than childbirth. It also affected their whole historical notion of the history of abortion that you read in the Roe and Doe opinion. So this was essential to the outcome, and yet there was no reliable data in 1970, 71, 72 to reach this assumption. And 10 years later, in the Akron decision, Justice Powell refers to it as Roe's factual assumption and says in the Akron opinion that the states retained an interest in verifying the validity of this medical assumption. The third or fourth thing I found was how they got to the viability rule. There was, of course, no record, so there was no evidence on viability. What's viability mean? What is viability? What's its implications? And at the time, they thought that viability of the fetus came at 28 weeks gestation. But in the first two drafts of the opinions in Roe and Doe, Justice Blackmun said that the essential time or the cutoff comes at the end of the first trimester, approximately 12 weeks. and that thereafter the states can prohibit abortion. So that's the working assumption through the first or second drafts of the opinion and through the first and second rounds of oral argument, because the cases were re-argued in October of 1972 when Justice Powell and Rehnquist had joined the court, so there was a full bench of 9 justices in the re-argument. But if you go to oyez.org and you read the transcript, and of course the easiest way is just look at the transcript and press F5, and you can look for the word viability. The word viability wasn't mentioned once in 2 rounds of oral argument, in 4 hours of oral argument. The word wasn't mentioned once. So where did they come up with this? Well, after the second round of oral arguments in November of '72, Blackmun writes a second or third draft and he distributes to the justices. And then in late November and early December, they start kind of jockeying behind the scenes and lobbying each other as to the scope of this right they're creating. And Justice Marshall and Justice Powell prevailed upon Justice Blackmun to rewrite his opinion to extend this right to viability. And finally, in the third opinion that he distributes on December 21st, 1972, just a month before the decisions were issued, he finally comes up with a third draft of an opinion which expresses the viability rule in the trimester system as we know Roe versus Wade and Doe versus Bolton today. So, so that's how the viability rule was essentially became a part of the Roe and Doe decisions. These were things that I was surprised to find in the papers, and I hadn't found it in much scholarship before I looked at the papers. That's the first half of the book, the historical background. And then the second half of the book, I look at some of the implications of the lack of a record, the medical assumption, the expansion to viability and beyond. And one of those clearly is a public health vacuum. And by that I mean that the justices in Roe and Doe expressly said the states are prohibited from any health and safety regulations in the first trimester because we're going to defer to providers. And in 2 or 3 cases, as I outlined, in the 1970s, they said, we really mean this. And they summarily affirmed judgments striking down first trimester health and safety regulations or denied cert in 2 other cases in the 1970s. And even today, the court has never approved health and safety regulations in the first trimester, although the cases moving to the court this year or next year could present the question of the constitutionality of first trimester health and safety regulations. But up to now, the court has never yet approved them, and any that have been passed and are on the books in the states are threatened with creating test case litigation. Among the implications that I look at are this public health vacuum and what the court has done and might do about it. The court's a passive body. It only reacts to cases that are brought to it. It works through litigation. It works through cases. It can't regulate. It can't amend past opinions except through cases that are brought to it. So unlike local state public health officers that can step in and regulate and impose health and safety standards, the court can't do that. And it assumed the role of basically the national public health officer, or as Justice O'Connor virtually said in Akron in 1983, as the National Abortion Control Board. The court can't act. It can't step into the situation. It can't impose any regulations. And it can only act through cases, and yet it's denied case after case after case that's been brought to it over the years. I mean, since 1992, the court has only heard of 3 abortion cases. The Stenberg case from Nebraska here in 2000, the AUL case from New Hampshire, I think it was 2006, and the Gonzalez case involving the federal partial birth abortion law in 2007. So just 3 cases since 1992. It doesn't take a lot of cases, and yet how can it understand the implications and the outcome of its handiwork unless it takes cases and decides them? The second thing that, or one of the other implications that I look at in the second half of the book is what some scholars have called the schizophrenia, meaning on one hand the court completely occupied the area of abortion law, and Roe and Doe are limited to abortion law and nothing more. But the states before 1972-73 and since, even more since then, have enacted wrongful death laws, fetal homicide laws, prenatal injury laws that all apply to protect the life of the fetus. And these laws have moved ahead year after year after year, providing more and more legal protection. So we've got prenatal injury laws in virtually all 50 states, which protect the fetus, unborn child from conception. We've got fetal homicide laws in 36 to 38 states. 25 of those, meaning half the states in this country, have a fetal homicide law that extends from conception. And we've got wrongful death laws in 36 to 38 states, and approximately a dozen of those, meaning wrongful death laws that apply to the unborn child. Wrongful death laws obviously are in all 50 states, but those that apply to the unborn child in 36 to 38 states, and about a dozen of those with protection from conception. So the court in Roe and Doe, and in no case since, has dealt with, can the states pass these other laws? And yet the states have moved ahead with a great growth of state law, creating what a number of scholars have referred to as schizophrenia. The court has denied some of these cases involving wrongful death, fetal homicide, prenatal injury, and has never dealt with this contradiction. And I presume never will, based upon its record up to now. I also look at the question of public opinion. The media, the public often talks, especially in the media, about how the public is polarized over the issue of abortion. That suggests that 50% are on one side of the spectrum and 50% are on the other side of the spectrum. And that's not what polling data shows. It may show that 10 or 15% support abortion without limits, and 10 or 15% would prohibit any abortion for whatever reason except to save the life of the mother. But the polls consistently show that there are 70% of Americans, 60 to 70% of Americans in the middle who would support abortion in certain circumstances early in pregnancy. And that majority in the middle has held pretty consistent. If you look at Gallup polling data, as I detail in Abuse of Discretion, if you look at Gallup polling data annually since 1975, you find 60 to 70% of the public in the middle supporting a policy of abortion in certain circumstances early in pregnancy. And that majority could form public opinion if the court returned the issue to the people. So I explore some other implications of the court's decision in the second half of the book, but I wanted to point out that although there's a lot of history in abuse of discretion, it's not just history, because the implications of the original decisions are and will be, and I think will come before the court in future cases. There are cases in the courts now in a number of different circuits. There's a split in the circuits on cases of admitting privileges. Can the states impose admitting privileges at local hospitals? There's a split in the circuits now. That case could be before the court. Those cases could be before the court this year or next year. There's a split in the circuits on regulations on chemical abortions in the first trimester. Those cases could be before the court this year or next year. There's a split in the circuit on that. Since the Gonzalez case in 2007, 13, 14 states have passed 5-month limits on abortion. And although the court denied review in the Arizona Ninth Circuit case last January, those cases could come up before the Supreme Court. And the 20-week cases, or the 5-month cases, would retest the question of the viability rule, as well as the assumption that abortion is safe from childbirth, the admitting privileges, regulations on first trimester abortions, could raise the question of the continuing validity of the medical assumption that abortion is safer than childbirth. So this is not just history. These issues are alive and will continue to be so in cases coming up to the courts in future years. So I wanted to leave plenty of time for questions and answers, because I thought that my comments might provoke a few questions. So when I was done with the justices' papers, and it was a tremendous experience looking through the justices' papers, I concluded that instead of being a kind of a measure of inevitable progress, Roe was a tragic mistake that happened at a unique moment in the court's history when there were these two vacancies, and a unique moment in American history at the end of the cultural turmoil of the 1960s. And the papers led me to believe that Roe was kind of the perfect storm. It was a unique combination of impulses and errors and miscalculations that came together during a brief 10 years of American history. And given the court's track record since in Roe and Doe and since Roe and Doe, what justifies the court continuing as the National Abortion Control Board? I mean, why should abortion, among all the public health issues, all the medical issues, health issues that Americans face, why should abortion be controlled by judges? And 41 years later, I think those questions still need to be asked and still need to be answered. So thanks for coming today, and I think I'm going to have a respondent, and then we'll open it up for questions.
Most of you probably already know him, but for those of you who don't, I'd like to introduce Professor Richard Duncan, who's going to provide some commentary, and then we'll open it to the floor.
Well, I am the commentator for Clarke Forsythe's presentation. And this is a little awkward because I basically agree with just about everything he just said. The students tried really hard to find a pro-choice speaker to respond to Clarke, to provide a different viewpoint, but no one was able to be here today to fill that role. But I think they literally asked 7 or 8 or maybe even as many as 10 lawyers and professors if they could do this. So what I'm going to do instead is try to channel my inner Ruth Bader Ginsburg and ask Clarke a tough question. Justice Ginsburg recently quoted, this was in her Hobby opinion, which isn't about abortion, it's about the contraceptive mandate, but in her dissent in the Hobby opinion, she quoted from the Casey opinion. And she said the following, she said, "The ability of women to participate equally in the economic and social life of the nation depends in large part on their right to control their reproductive lives." So I think the point she would make, and I think she agrees a little bit that maybe Roe was wrongly decided as a matter of substantive due process. It probably, I think she would say, should have been decided as an equal protection case. And so I think if she were here today, she would say something like the equal protection for women requires a constitutional right to abortion through all or most of the period of pregnancy, because women need reproductive autonomy in order to have the same control over their economic and social lives that men have over theirs. So how would you answer Justice Ginsburg's equality for women argument? And then we'll go to Q&A, because that's pretty much what I wanted to do.
Okay, thank you. Well, what Justice Ginsburg was citing, as Professor Duncan said, is the court's decision for Planned Parenthood versus Casey in 1992. And in 92 in Casey, the court completely shifted the rationale for Roe versus Wade and Doe versus Bolton. The rationale for Roe versus Wade and Doe was history, that there was a right to abortion deeply rooted in Anglo-American history. Since then, numerous scholars, books and articles, dozens of books and articles have repudiated that history and the substantive due process on the foundation of Roe and Doe. And the court in subsequent cases kind of ignores that. Even Justice Blackmun ignored the historical foundation. And in the plurality of Justice O'Connor, Kennedy, and Souter, Planned Parenthood versus Casey, enunciate a new rationale for the abortion right. And that is a sociological proposition called the reliance interest, as Professor Duncan quoted, that women have come to rely upon abortion for equal opportunity as a backup for failed contraception for equal opportunity in American society. One of the striking things about that rationale in Planned Parenthood versus Casey is that the court goes on for pages and pages and pages about the reliance interests But there was no record in Planned Parenthood versus Casey on the reliance interest. There was no more record in Casey on the reliance interest than there was in Roe and Doe on the medical assumption or any other facts. Planned Parenthood versus Casey in the lower courts had a record addressing the 4 or 5 points of regulation of the Pennsylvania statutes. And when Pennsylvania appealed the cases to the Supreme Court, the court pointedly rejected hearing arguments on the validity of Roe and Doe, and specifically told the parties to just brief the regulations from Pennsylvania. But then when the case was argued, then some of the justices felt a necessity to preempt future challenges to Roe by deciding the validity of Roe and Doe and adopted the reliance interest. So the reliance interest, the basis for the reliance interest, if you look at Planned Parenthood versus Casey, is one page of one book by Rosalind Paczewski, and you can see it there in the Planned Parenthood versus Casey plurality opinion. That's the basis for the reliance interest. There was no factual basis. So it too is an assumption, and I would say that, you know, if it's so absolutely clear that that's true, then we should be clear that the American people would support a right to abortion if the Supreme Court returned it to the states. And in fact, if Roe versus Wade, I think it's many people are surprised to find that if Roe versus Wade was overturned today, abortion would be legal in 45 or 50 states tomorrow, up to 20 weeks if not viability, because there are simply no enforceable prohibitions on the books. So there would be no immediate short-term change. The issue would go back to the states and the state legislatures, and the good thing about that is that public policy would be more in sync with public opinion. And one of the, based on my review of the justices' papers, is one of the reasons this controversy continues 41 years later is because the justices' sweeping decision is so out of sync with public opinion. And if the issue could be returned to people, public opinion and public policy would be more in sync. There would be no short-term change. The issue would go back to the state legislatures. Public opinion would have its impact. And it's obviously impossible to predict where would the states come out 1 or 2 or 3 years later. But I suggest in abuse of discretion that after 2 or 3 legislative sessions across the country, you might have half a dozen states or 10 states limiting abortion very strictly. You might have 10 to a dozen states allowing abortion as under Roe versus Wade, maybe as many as 15 to 16 because there are state Supreme Court decisions adopting Roe and Doe at the state level that would probably prohibit limits. And then you would have 30 states in the middle that would allow abortion maybe in the first trimester for broad reasons, or even first or second trimester. But it seems to me that if the reliance interests are so blindingly clear and true, that the American people would adopt those in forming public policy if Roe was returned to the states. Questions?
Yeah, and this is for either of you. Are you able to think of any other case where a case goes before the court with no trial record, which as a practicing lawyer, I just can't imagine that this actually occurred and shifted public policies it has in our country, where they took it on what may be a procedural issue, but then decided on substantive grounds, relying upon their facts from a friend of the court or multiple friend of the court briefs in order to supply them with the facts that they need in the opinion. Well,
cases before Roe and Doe, going back decades, and since Roe and Doe, have the court has often said that we will not decide a constitutional case. We will not decide constitutional issues without an adequate record. Go all the way back. My favorite one is Justice Brandeis's opinion for a unanimous court in 1927 in a case called City of Hammond versus Shabby Bus Lines, in which Brandeis writes, quote, "Before any of the questions suggested, which are both novel and of far-reaching importance, are passed upon by this court, the facts essential to their decision should be definitely found by the lower courts upon adequate evidence. And the court has said this numerous times. But here's the problem, and kind of what I feel was kind of my failure in looking through the justices' papers. The decisions were decided 7-2, and the original dissenters were only Justice Rehnquist and Justice White. And in light of the record, I would have thought that the dissents would have made this point. But if you go back and read them, neither the dissent of Justice White nor the dissent of Justice Rehnquist makes this record point. And the papers of White and Rehnquist shed no light on why didn't they raise this. And I've got to think that the only other collection of papers I wasn't able to see, which was Chief Justice Berger's, I assume won't shed any light on this question because he was kind of AWOL throughout these cases. There's no imprint of his whatever on the other papers. There's no memos back and forth. I think he was just preoccupied with other cases and administrating the court as Chief Justice. And only very late in the game, in like January of '73, does he first mention to Justice Blackmun that he's going to write a concurrence, a short concurrence, and it was a very short concurrence. So why didn't Rehnquist or White touch on the record issue? I don't know, and I wish I had an answer, but I don't. Other questions? Yes?
You seem fairly well versed in most of the Supreme Court justices' papers, as well as I've heard anyone speak on, so I congratulate you for looking through all those. I guess what troubles me about this case, about Casey, about some of the same-sex marriage cases we're seeing currently, do you detect, I guess it's a two-part question, back in the Roe and Casey era, did the justices' papers reveal that people perceive their paternalistic rulings as arrogance on the court's part, essentially an unelected decision on moral judgments by these guys in black robes? Or did they really think that people would accept their viewpoints and essentially move ahead with their lives? I mean, it just strikes me that they couldn't have seen what was coming, the firestorm that happened by them taking this from the states and just deciding such a contentious issue.
Thank you. The question is about whether they anticipated the political backlash. There was Justice Blackmun, in writing the opinions or the drafts, would periodically told the justices, "We're going to get criticized for this," or "I can imagine the newspaper headlines," or "The newspapers are going to criticize us," or something. He would warn the justices from time to time that they were going to be criticized. But I think scholars of every philosophical persuasion have kind of uniformly said that they didn't realize the extent of the criticism that would come. And so they had an inkling, but they I think firmly believed that they were pushing the public opinion wave, that they were ahead of history, that they were riding public opinion toward legalization of abortion, and that they were only expressing where public opinion was. And again, there was no record on public opinion, even if there should be a record of public opinion. So I think they clearly misjudged public opinion. And I would say they misjudged public opinion in three ways. They looked at the polling data, and the polling data was kind of all over the place in the 60s and early 70s. But for example, in a year or two before the decisions, they could look at a poll that said, asked the question, should abortion just be between a woman and her doctor? And 60% of Americans would agree with that. But in January '73 or December '72, I mean a month before, a month after, the same public opinion poll with Gallup data basically evenly split, like 45-45, yes, no. So public opinion was fluctuating. The second thing that I discuss in the book is that in 4 state legislative sessions in until 1967, most states prohibited abortion except state of life and murder. But starting with the legislative sessions in 67, 68, 69, 70, 4 straight years, about 13 to 14 states legalized abortion to some degree. And by the time of Roe, 30 states still retained their prohibitions except to save the life of the mother, and about 20 states had introduced some exceptions into their abortion laws. But none were as broad as the outcome in Roe and Doe. But the interesting thing is that after those 4 legislative sessions, 67, 68, 69, 70, in 1971 and 72, and there were legislative hearings in all 50 states, no state in 71, 72 changed their laws by legislation. And it seemed like, public opinion had kind of, to some extent, spent its force by 71. And in 71, 72, there were no changes in the states, and there were some referendums actually in, I think it was North Dakota and Michigan, which had rejected legalization on ballot initiative. And the third thing is that if you hear the oral arguments and read the transcripts on OEA.org, you'll hear Dorothy Beasley, the Assistant Attorney General for Georgia, talk about fetology and fetal medicine, but never once do you hear anything in the oral arguments about ultrasound. And ultrasound only hit the commercial market in the United States 3 or 4 years after the Roe and Doe decisions. The justices didn't apparently have any inkling about it, and I think it blindsided them, and I think it has permanently changed public opinion, and they didn't see it coming. And so for those 3 reasons, I think they had weak evidence as to riding the public opinion wave, and were surprised and shocked. Other questions? Yes?
I ask your opinion of a hypothetical. If abortion were returned to the states, don't you think that in a matter of time, we'll be back in front of the Supreme Court on a different constitutional basis as gay marriage is now?
Well, it might be. It might be. It depends on how the justices dealt with the original opinion. I mean, it might come back on certain applications, yes, but I think if a majority returned it to the states, it might be years before it actually came back. A court was reconstituted that might reverse the reversal. But it's certainly possible it could come back on equal protection or some other theory. That's possible, sure. Yes?
I find it glaring omission of having no representation of the unborn child. The one quote, potential individual who has no representation in any of this, do you see that as a possible future change in the jurisprudence of at least a viable fetus having some representation in the courtroom?
It's hard to predict what the future might hold. I don't see it happening because of the court, since Roe and Doe has uniformly rejected appeals by individual attorneys representing individual people, fathers, unborn children represented by guardian ad litem. The court for 41 years has uniformly rejected those cases. The paradigm that the court has stuck to is hearing state officials defending state laws and representing state interests. And that is the paradigm the court has consistently worked with. And so for that reason, I don't see them taking cases from individual attorneys representing individuals of any stripe. But what's interesting is that Roe and Doe were only 2 cases of 20 to 24, which were in the courts from different states in 70, 71, 72, 73. And some of those other cases had better records. And some of those other cases did have guardian ad litem who intervened as intervening defendants and tried to present, and in some cases, I guess, did present a factual record. But the court did not take those cases. And the court, unfortunately, the court took the cases with no record. But there were cases in the courts advancing that theory. But in the 70s and 80s, guardian ad litem were more frequently denied intervention and denied a right to intervene. And so I don't see that in the future. Other questions? Yes?
My impression has been that the context for Roe versus Wade had been some prior decisions on striking down some contraception laws where they expected some negativity out of that and didn't get it, and so perhaps that played into their view of public perception. Is there any basis for that?
Yes, I think that's absolutely true. One of the interestingly, well, as you know, Griswold was decided in 1965, and there was very little kind of, or at least that I could find, no significant public reaction against Griswold versus Connecticut. But then, what's interesting is that in the 15-week vacancy in which the court first heard Roe and Doe, the 4-3 split also heard and decided Eisenstadt versus Baird. And if you go back and read Eisenstadt, it was a 4-3 decision written by Justice Brennan. Eisenstadt versus Baird applied Griswold, which struck down a criminal prohibition on marital abuse. And in Eisenstadt versus Baird, the court 4-3 struck down regulations on the sale of contraceptives to singles. And so they extended that decision in Eisenstadt versus Baird, and Justice Brennan stuck a passage into Eisenstadt versus Baird and distributed on the day that Roe versus Wade was first argued, and said, this will help in the abortion cases. And the passage in Eisenstadt versus Baird was about a right to bear or beget, a constitutional right to bear or beget, which didn't really apply to the facts in Eisenstadt, but applied to the facts in Roe versus Wade and Doe versus Bolton. And that right to bear and beget made its way into the Roe and Doe opinion. So Eisenstadt was used as a precedent for Roe versus Wade and Doe versus Bolton was written in the opinions. Other questions? Well, thank you very much for coming. Appreciate it.